Most mild TBI clients look normal, no visible scars, no slurred speech, just a regular person sitting in a courtroom. So what happens? The jury starts thinking, they seem fine to me. Why are we here?
TBI cases can feel like navigating uncharted territory. Your client's injury is real, but proving it? That's where the real challenge begins. If you've ever felt like you're missing crucial pieces of the puzzle, you're in the right place. Welcome to Winning the TBI Case, where Tom Crosley shares the insights he's gained from over 60 injury trials. Not just the victories, but the lessons learned along the way that make all the difference. This is practical wisdom from someone who's been in your shoes and found a path forward. Winning the TBI Case. Strategy, science, and storytelling. In this episode, Tom reveals courtroom strategies that may surprise you. Let's join Tom as he explains why you shouldn't prep brain injury clients the way you would other plaintiffs, and how to keep their testimony short, authentic, and powerful.
Welcome back to Winning the TBI Case. I'm Tom Crosley, and today we're talking about one of the most high-stakes moments in a brain injury trial, introducing the plaintiff and having them testify. Now, we've already built the foundation by now. The jury has seen the science, if we've done it right. They've seen objective, irrefutable proof of brain damage. They've heard the human stories from before and after witnesses, painting a picture of how life has changed. So now it's finally time to introduce the plaintiff. But if you do this wrong, you undo all of that hard work. Here's the problem. If you bring your client in too early, before the jury understands their injury, then the jury will start making snap judgments. That's the way we humans are wired. And so let's be real. Most mild TBI clients look normal, no visible scars, no slurred speech, just a regular person sitting in a courtroom. So what happens? The jury starts thinking, they seem fine to me. Why are we here? Is this just a money grab? We don't want them thinking that. And once a juror has that first impression, it's almost impossible to shake. That's why timing is everything. You do not put the plaintiff on the stand until the jury is primed to see their injury, not just in medical terms, but in human terms. So how do you do it? Let's break it down. Delay the plaintiff's presence in court as long as you can. It might sound counterintuitive, but in most TBI cases, I don't let the jury see my client until the client testifies, which is deep into the trial, near the very end. Maybe right before I have the life care planner and economist, but certainly one of my last witnesses. I might have 20 witnesses in my case, and the plaintiff might be the 17th witness. Sometimes I will have brought the client in to introduce them to the jury in jury selection, but I usually don't keep them there during jury selection. I certainly don't want the client listening to all the testimony from other doctors, scientists, brain injury experts, before and after witnesses, talking about how this person is all messed up and is not the same person anymore. That isn't good. I don't want them to have to listen to all that. I don't think it's good for their mental health. It's pretty awkward. Certain witnesses, especially before and after witnesses who are close to the plaintiff, won't be as raw and vivid with their descriptions if the person is sitting right in the room looking at them. It's hard to talk bad about somebody when they're sitting right in the room. So we have a lot of reasons why we want to keep the plaintiff out. And some of them are actually psychological, emotional health reasons. Typically, a doctor or psychologist or someone, if asked, will write a letter or make a recommendation that for the plaintiff's emotional and mental and psychological well-being, it is best that they not be exposed to all the testimony about their brain injury deficits and the long-term outcomes for them, because it would not be good for them. And that's all you really need to keep them out of the courtroom. So remember how I mentioned that sometimes I'll bring the plaintiff in to introduce them to the jury, and maybe I'll bring them in for opening statement. I remember one case, I brought them in during jury selection. But first, I covered this concept called "Don't Judge a Book by Its Cover." And I had this image, and it's a girl laying in a field facing the camera, and it's a girl with pigtails, and she's holding a book, and the book just has a blank blue cover. and I don't even have words on the screen. And I say, hey, who here has heard of the term, don't judge a book by its cover? Everybody's hand goes up. That's a great theme in a TBI case, especially one where the jury will see your client before they testify and before they learn about the injury. And we talk about that in jury selection. So I can introduce this concept that you won't meet this person until you have enough information to judge them. And who can wait and judge this book by the contents of the words on the pages rather than what's on the cover. And everybody gets along fine with that concept. And so that's one way I've done it. I've done it a bunch of different ways, but the point is, let's delay the plaintiff's presence in court as long as possible. We want the jurors making judgments based on what they see, not what they're told. And if they spend days watching the plaintiff just sit there and looking fine, their perception becomes, hey, this plaintiff is probably fine. So instead, I like to build the case first. I want experts to show brain scans using real images and proving real injury. I want before and after witnesses to describe personality changes, as I've discussed on prior episodes. I want the jury to start expecting to meet someone who is truly suffering, already looking through the lens of this is a real injury, as opposed to still wondering by the time the plaintiff testifies, hey, is she faking it? So when the plaintiff finally appears, the jury shouldn't be thinking they look fine. They should be looking for subtle signs of the injury, the hesitation, the confusion, the emotions, and that's the game changer I'm looking for. So I've used video deposition excerpts of my plaintiff to introduce the plaintiff gradually. I introduce them in these small controlled doses, and I curate the clips, usually to match up with one of the symptoms of their TBI that's consistent with the case. It's, either forgetfulness or mood lability, which is rapid changes in mood. It could be getting distracted, losing their train of thought, word finding difficulties, whatever it is. I'm going through the evidence in my case and the medical records, and then looking for clips that match that. And those clips are often getting played with experts. They could also be played with before and after witnesses. Hey, I want to show you this clip of Mary, and then I'll ask you some questions about it. Show the clip, ask the questions. The whole point of that was to show the jury Mary struggling with whatever the question was in a way that's consistent with her TBI. So I use the clips strategically. Doctor, based on what we just saw, how does this behavior relate to the areas of brain damage that you saw? What is significant about the clip that we just saw? Oh, that's classic TBI. That's somebody forgetting their word finding difficulties. That's very commonly reported in this type of TBI, whatever the issue is. So we want the jury to feel like by the time the plaintiff takes a stand, that the jury already knows them. They've seen glimpses of their struggles. They expect the deficits, and they see what they expect. And that changes everything. The perception is different when we sequence the evidence correctly.
If you're finding value in today's episode, here's how you can take your TBI practice to the next level. Subscribe to our newsletter at crosleylaw.com/podcast for exclusive case studies, resources, and trial strategies you won't hear anywhere else. That's crosleylaw.com/podcast, or click the link in the show notes below. Don't just listen to the strategies, implement them.
So I was invited to assist in the trial of a TBI case recently with some really fine lawyers, and they needed help prepping the plaintiff for her testimony. And they wanted to spend a full day getting her ready to testify on a weekend. I said, oh, I wouldn't do that. And they said, well, why not? We always prep the client, make sure they're perfect as can be. And I said, well, that makes sense in most cases, because you want your plaintiff in most cases to remember things, to clearly recall the accident, to seem confident, to be believable. Those things enhance credibility. We think we want that in a case from our client. And that's true, but not in a TBI case. Because what happens if your client is very well prepped and comes across as confident, knows everything, doesn't struggle with finding answers because you prep them so much? You have just belied the whole point of the trial, which was to prove that these are deficits this person can't do. So instead, I do something that some lawyers think is counterintuitive. I don't prep them at all. I really don't. I just say, I get them in there. They look like a fish out of water. And I start asking them questions. And I'm not playing a game. I'm not trying to mislead anyone. I'm going for the authentic response of, tell me about X, without me having told them previously, hey, one of the first questions I'm going to ask you is tell me about X. I want people to see how they really react. I mean, if you put me on a stand and tell me about X, I'll confidently tell you about X to the extent that I can. But if I put my brain injury plaintiff on the stand and they struggle, and then they say, now, what was the question again? That's really what I'm going for. And I'm trying to keep them 30 minutes or less. I don't need to win the case with my plaintiff. In fact, I shouldn't rely on the plaintiff to win the TBI case. I need to win the case through other witnesses, experts and before and after witnesses, and what we call collateral witnesses. If I have to rely on the plaintiff to win, then I'm probably not going to win. There's another reason why we don't keep a plaintiff in. So if it's a mild TBI case, we don't want them in the courtroom because they look too normal. If it's a severe TBI case, say they're drooling or they're very, very obviously impaired, I don't want them in the courtroom through the life of the trial because the jury will become desensitized to seeing that injury. It's more shocking when you see it for a short amount of time than it is if you've lived with it for a week or a week and a half, seeing the person every day. And so they become desensitized to it. For the same reason, if I had a burn injury victim who looked horrific, I wouldn't have them sitting in the courtroom for their trial. I would bring them in briefly toward the end of the case, and I would take them out because that visceral impact remains with the jury. Same is true in a severe TBI case. So regardless of whether it's a mild TBI or a severe TBI, this adage still applies, which is delay the plaintiff's presence in your case and keep it short and to the point if you can. So less becomes more when the plaintiff testifies. I also don't like the witness to complain. We don't like our plaintiffs to be complainers because jurors don't like complainers. So if the plaintiff goes on and on about how their life is ruined and nothing is the same, even if it's 100% true, I'm afraid that jurors will tune out, that it'll come across as whining, and that it'll kill our credibility. So instead, I'm just really trying to use real life examples. Let actions, not adjectives, tell the story. That's so important. I'm going to say it again. Let actions, not adjectives, tell the story. And let the emotions come naturally. Most importantly, I never let the plaintiff try to sell their injury. There's a concept in brain injury called anosognosia. Literally means that they don't know what they don't know. So anosognosia is this concept that a plaintiff with a brain injury or a person with a brain injury is not aware of their deficits. And so they'll say, oh yeah, I'm fine. I can do that just fine. When in reality, they can't, which is why we're getting before and after witnesses to do that for us. We're not relying on the plaintiff to tell us what they can or can't do. And to the extent we do ask those questions, it's corroborating what others have already said. So typically I could be in a 2-week trial and the plaintiff is on the stand for 30 minutes and that's it. What else do I want to make sure you understand about the plaintiff when they testify? I'd like to come up with one big question that hits home. It could be a variation of this. It's, what is the hardest part of living with your injury? So we're going to figure out how to ask a question in a way that surprises the plaintiff to get at that answer. It could be something like, what do you miss the most about your life before this injury? Or what do you think the future holds for you now that you're different? You could come up with dozens of examples, but you're looking for something to put a bow on everything that creates an emotional impact at the end of the case. The answer must be powerful and it must not be rehearsed. So it could be something like this. What's the hardest part about your injury as you think about your life going forward? Well, I used to be the one who took care of my family and now they take care of me. Or I can't even sit in the same room with my grandkids anymore because I can't stand the noise. And I used to love sitting on the floor playing with them. Now I just put my noise canceling headphones on and go upstairs. I feel like I'm withdrawing from my own family. And that just kills me inside. That was an example from a case I tried last year. You'll find it. You just have to ask the right questions and you'll know when it's time to stop because you've got the golden response. What you're looking for is not about sympathy. It's about something real and authentic. A great answer to this question, whatever that wrap-up question is, makes the jurors feel the loss, makes it stick with them. And I'm never ending the case with the plaintiff testifying. Instead, I follow their testimony usually with a life care planner, MD, who's projecting future medical care needs, and an economist, and then finally one last before and after witness, whoever I think is my strongest one. And the reason I do that is it shifts the focus away from the plaintiff's own words and onto the impact that the injury has had on the people around the plaintiff. Because those people sometimes come through as more credible than the victim themselves. So it could be a spouse who says, I lost my best friend. It could be a child who says, my dad used to be my hero, and now I'm his caretaker. Or it could be a coworker who says, he was our go-to guy. We miss the guy he used to be. Place isn't the same without him. Or maybe he's still there. The place isn't just the same. You'll find the gold. So let's bring it all together and recap. Delay introducing the plaintiff. Don't let jurors make snap judgments too early. Number 2, use video clips to introduce your plaintiff gradually. Don't just tell. Try to do a show and tell. Number 3, keep the testimony short, honest, free of exaggeration, and unrehearsed. Number 4, ask some variation of what's the hardest part of living with your injury going forward. Make sure the answer is simple but powerful. And finally, follow it all up with a strong, compelling before and after type witness. So in one of the next episodes, we're going to talk about cross-examining the defense's junk science experts, because nothing is more satisfying than tearing apart a flimsy defense theory in front of a jury. Until then, remember, it's not just what your plaintiff says, it's when and how they say it. This has been Winning the TBI Case with Tom Crosley.
If today's episode helped you see your current case in a new light, share it with a colleague who's facing the same challenges in a case. Subscribe wherever you get your podcasts and join our community of trial lawyers who refuse to settle for average results. This has been Winning the TBI Case. Strategy, science, and storytelling with Tom Crosley.